Employees everywhere are receiving notices from their employers giving them 3 options. Number 1, take the COVID-19 vaccine. Number 2, subject yourself to weekly COVID-19 testing. Or 3, get fired. I've received a lot of phone calls from individuals lately asking if this is illegal. And this situation triggers several different bodies of law. Number 1, California Wage and Hour Law. Number 2, Title VII, the ADA, and personal freedoms. This video will explain if your employer can require you to take the COVID-19 vaccine, if there are any exceptions and what those exceptions are, and the applicable wage and hour claims that pop up when employers require this mandatory testing. My name is Adam Juratovac, and I'm a California employment lawyer based out of the San Francisco Bay Area. And welcome to my channel. 2 months ago, I launched a law pack on my website, and this 137-page law pack answers the question, can your employer require you to take the COVID-19 vaccination, and what exceptions to the rule there are? Now you can find this on my website, and right here we have the first 25 pages, because this law pack has over 100 pages of exhibits from the CDC and EEOC. So can your employer require you take the COVID-19 vaccination? The short answer is not necessarily. Based on guidance provided by the EEOC, employers can require their employees take the COVID-19 vaccination, unless those employees fall under an exception to that rule. The first exception to the rule that I want to discuss is a reasonable accommodation from the vaccination requirement. Depending on the circumstances, Title VII or the ADA may require employers to provide a reasonable accommodation to employees who do not want to take the COVID-19 vaccine. Now, this doesn't mean that employers can be subject to an undue hardship by providing this reasonable accommodation to their employees. 2 reasons why an employer may require a reasonable accommodation for an employee are because of a disability or because of a deeply held religious belief. Now I'm going to start reading straight from the law pack because all the information is in here and you can find this on my website. Under the ADA, absent undue hardship, employers must make a reasonable accommodation for a qualified employee with a disability. Reasonable accommodation may include, among other things, appropriate adjustment or modifications of employer policies, for example, exemption from a mandatory vaccination policy. Title VII applies different rules though. Under Title VII, requires employers to reasonably accommodate an employee's sincerely held religious belief, practice, or observance unless it would cause an undue hardship on the employer's business. If an employee refuses to receive a vaccine based on disability or religion, the employer should explore possible reasonable accommodations before prohibiting an unvaccinated employee from working. And the employer should not take any adverse actions on that employee for requesting a reasonable accommodation or a religious exemption. Specifically, the employer should explore through the interactive process whether that reasonable accommodation brings an undue hardship upon the employer. And if it doesn't, and if through that interactive process there's a reasonable accommodation that can be made for that employee, the employer should try to grant that reasonable accommodation. They need to go through the interactive process. And these are some examples of what the interactive process looks like. And again, you can find this all in this law pack. It's only 20 bucks. First, the employee needs to request a reasonable accommodation from their employer based on either a disability or a deeply held religious belief. Then the employer needs to engage in the interactive process, and this is what it could look like. The employer should identify the employee's limitations, and here the limitations is undertaking on the COVID-19 vaccine. And this could even include reviewing the COVID-19 vaccine's contraindications. And I wrote in a note here, it says, conditions in a vaccine recipient that increases the risk of a serious adverse reaction, and precautions. Conditions in a vaccine recipient that might increase the risk for a serious adverse reaction, cause diagnostic confusion, or compromise the ability of the vaccine to produce immunity. The second part of the interactive process that an employer should undertake. Considering possible accommodation options given the nature of the workplace and the employee's condition. So if your employer is allowing people to work from home or work remote 100% of the time, I don't think that employer should require its employees to undertake the COVID-19 vaccination. Now, if your job or part of your duties is customer facing or you need to be in a small office space with a lot of other coworkers, then your employer needs to engage in a little bit more in-depth interactive process seeing that if a mask would be able to help or be able to satisfy the requirements, or if allowing you to have another office where you can close a door by yourself, if that would allow for a reasonable accommodation for you not to take the COVID-19 vaccine. And another part of the interactive process that an employer may be able to take is to obtain supporting documentation about the employee's disability if necessary. This may include, for example, an employee's history of previous allergic reaction or documented allergy testing to indicate an immediate hypersensitivity reaction to a vaccine or a component of the vaccine, which, depending on the facts and circumstances, may or may not be considered a disability under the ADA. What this means is, in certain situations, your employer is able to ask for a doctor's note stating what kind of accommodations you would need and what would be reasonably accommodating in your situation. Just because your employer asks for a doctor's note does not necessarily mean that there's disability discrimination. Your employer is able to ask for supporting documentation when you request a reasonable accommodation under the ADA or Title VII. For accommodation requests based on religion, the EEOC's COVID-19 guidance says this. Now, one type of religious objection is that an individual wants to wait for a specific brand or a different alternative version of the COVID-19 vaccine to be available before they actually take it. Now, what every employee needs to remember is that the religious exemption is broad. It's broad and it protects beliefs, observances, and practices which the employer may be unfamiliar with. There are a lot of individuals who do not like the COVID-19 vaccine as is because it may interfere or it may mutate your DNA. There are certain individuals who are Christian who believe that their body is the temple of Christ. Now, when your body is the temple of Christ, everything that you receive, everything that you put into it, is also part of that temple. There are certain types of vaccines and there are certain shots that people take that interfere and mutate your DNA. Now, so for individuals who believe that their body is the temple of Christ, they may not want their DNA mutated. So there's a lot of individuals who very sincerely have this belief. And there's also a lot of individuals who like taking drugs and start doing other things who will try to say that this is their religious belief. So one thing that people need is they need to have a close relationship with their pastor, priest, or other type of religious leader. Because if notice is required, if your employer requires a note, then you need to have a good relationship with that religious leader so then that they can speak on your behalf. Now, if you request a reasonable accommodation under Title VII for a religious exemption, then the accommodation must be based on a sincerely held, closely held religious belief, which means you can't just make up a religion and say that it's against your religion. That's ridiculous. If an employee requests a religious exemption for this COVID-19 vaccination, the employer may request supporting documentation or additional information, especially if the employer has an objective belief of the sincerity of this religious accommodation request or the sincerity of this deeply held religious belief. Employers don't need to provide a reasonable accommodation if that would in fact lead to an undue hardship for the business. And the standard for an undue hardship for the business differs whether the reasonable accommodation is based on a disability or a deeply held religious belief. In the same breath where we talk about what an undue hardship would be for an employer, we also have to discuss what reasonable accommodations can be. Examples of reasonable accommodations for exempt employees may include 1. Permitting an unvaccinated worker to enter the workplace if they 1. Wear a mask, 2. Stay socially distant from the other employees, 3. Work a modified shift, or 4. Periodically get COVID-19 testing. And of course there's other ways to reasonably accommodate these individuals, like allowing them to telecommute, or 2, reassigning them in a different position. So the next 5 pages of this law pack is primarily for employers and ways that they're able to articulate to their employees, what types of reasonable accommodations they should accommodate, what type of presumption they should have when one of their employees gives them a reasonable accommodation request, and you can find that in the law pack. When an employee requests a reasonable accommodation based under Title VII for a religious exemption, there's a different process that the employer must take to evaluate whether they can reasonably accommodate that request. Normally, your employer must assume that your reasonable accommodation request based on religion and specifically a deeply held religious belief, is true and it is presentable. Second, your employer can request supporting documentation for you to prove that you have a deeply held religious belief that precludes you from taking the COVID-19 vaccine. Now, after your employer receives that request, they need to evaluate whether that reasonable accommodation request provides them with an undue hardship. After receiving a reasonable accommodation request, your employer must evaluate and determine the proportion of employees in the workplace already partially or fully vaccinated against COVID-19, the extent of employees' contact with non-employees who may be ineligible for a vaccination or whose vaccination status may be unknown, and 3, CDC recommendations. Now, if your employer provides you with a reasonable accommodation, the EEOC guidance also reminds employers that the ADA prohibits employers from 1, disclosing that an employee is receiving a reasonable accommodation, although wearing a mask inside might blow that front up, and 2, retaliating against an employee for requesting or receiving a reasonable accommodation. If an employer cannot reasonably accommodate an employee who requests a reasonable accommodation, the employer should not take an adverse employment action against the employee until they evaluate every other body of law that may apply to that employee. Now, this video only applies to individuals who either have a disability as identified and recognized under the ADA, or individuals who fall under the religious exemption in Title VII who have a deeply held religious belief that preclude them from receiving this COVID-19 vaccine. Now, if you have a disability or if you have another health condition that doesn't quite hit the threshold of a disability under the ADA, or you have a religious belief that isn't deeply held or is not sincere, then you do not fall under these exceptions that I've just identified. I just explained 2 exceptions where an employee cannot be required to take the COVID-19 vaccination. Some employers are now requiring their employees to either take the COVID-19 vaccination or be subject to weekly testing. Now, it is firmly held California labor law that if your employer requires you to undertake a COVID-19 test, then that is compensable time. What that means is, if your employer requires you to take the COVID-19 test as part of your work, they need to pay for that time it takes you to take the COVID-19 test, and the time it takes you to clear getting that COVID-19 test paid for by your insurance. So I don't care if your employer says that if you take weekly COVID-19 testing, you won't get paid. You should still track your time because that is compensable time under California Labor Code. And if your employer is refusing to pay you for that time where they require you to take a COVID-19 test, make sure you write in an email saying that you are going to take the COVID-19 test because that's an accommodation that your employer is allowing for this COVID-19 requirement, but then you believe that you should be paid for the time it takes you to get that COVID-19 test. And then you end that email. And if your employer treats you adversely, or if they treat you poorly because you made that request or because you called out that flaw in the employer's policy about violating the California Labor Code, then you should come see an attorney. Now, I just got done reviewing the first few pages of this law pack that explains whether your employer can require you to take the COVID-19 vaccine and what are the exceptions to the rule. Now, if you're interested in learning more, about your rights in depth under the ADA or Title VII, then feel free to check out this law pack. You can find the link for it in my bio. We're in the midst of a global pandemic due to the coronavirus. And because of that, employers should think about protecting their customers, they should think about protecting their employees, and they should think about protecting their business partners. Now, right now, the EEOC says it is okay for employers to require a mandatory vaccination for their employees. Now, no rule is absolute, and there are exceptions. There are exceptions to the rule. There are reasonable accommodations that the employer can make. But at the same time, this video is not meant to educate people who solely want to get exempted from taking the COVID-19 vaccine. This video is meant to educate, this video is meant to explain, and this video is meant to allow individuals to understand their rights under the ADA and under Title VII, especially when it comes to religious exemptions and health exemptions for disabilities under the ADA. Now, there are different issues, and as an attorney, when I see different issues with the law, I will always spot and check out those issues with the law. Now, I know a lot of employers are requiring that unvaccinated workers subject themselves to weekly testing. Now, under California Labor Code, that time is compensable and you must be paid for that time you spend getting tested each week. And your employer must pay that. Now, this is not a video where I'm going to talk about the ethics in getting vaccinated. I'm vaccinated. I'm fully vaccinated. But this is a video that'll explain your rights under California and federal law. And I do believe that it's important for people to know their rights. More importantly than it is for me to judge people based on those rights and those beliefs. So if this video helped, if this video educated, please feel free to share it with your friends. And if you're having trouble requesting a reasonable accommodation based on a religious or a disability reason, then please contact an attorney.